You are watching DHTV from California State University, Dominguez Hills.
Hi, I'm Dr. Pamela Kreiser, and welcome to NCR 525, which is our course in mediation. And this course is really about the theory behind mediation, as well as understanding the skills that are involved in mediation. Now, I'm your instructor for the course, and I want to tell you a little bit about my background. I first became interested in conflict resolution in the late 80s when I worked in youth mediation programs. And then after that, earned a master's degree at San Jose State University, studying conflict, and then finally a PhD in interpersonal communication and quantitative methods, and that was at the University of Texas at Austin. Now, I bring to you a varied background, honestly, because truly I'm an academic, but I'm also a practitioner. What does that mean? That means that I have the academic side of what I do. I work on the graduate faculty at Cal State Dominguez Hills in mediation, and also in quantitative methods. And then I also am a practitioner in that I serve regularly as a mediator in the Superior Court system. And so that means that I can help give you a perspective from both sides. So as we talk about theory, we also want to talk about what works in this course. Now, this particular session, we're going to go over 7 different topics, and they are the following. We're going to talk about alternative dispute resolution. We're going to differentiate mediation and arbitration. We're going to talk about the role of the mediator, identify theoretical reasons for mediation, the benefits of mediation, what is DERPA and who can mediate, and finally talk about DERPA regulations and requirements. Now keep in mind, this is an online learning environment. And so what that means is that if you're enrolled in this course for course credit at the graduate level, it'll be important that you check onto our online system very frequently. So make sure you pay attention to the discussion boards, the lectures, the other posted materials so that you can get the best experience possible. And that just means checking back very frequently. Now to start our conversation, we want to start by talking about the term ADR. And this is what's known as alternative dispute resolution. When we use this term, we mean that it is an alternative to the formal court proceeding. So when you think about this larger box of ADR, you might think about it as a larger category of which mediation is a part, arbitration is a part, collaborative law. There's a lot of different formats, including mediation arbitration. And all of those different formats are all one or many different ways to alternatively resolve conflicts. And so this is a very big growing area in our world right now because we have no shortage of conflicts, of course. And so we're looking all the time for new ways to solve those conflicts. And so I mentioned that I serve in the Superior Court system. I mainly do small claims and civil harassment cases. My keen interest really is more in civil harassment because of my specialization in interpersonal communication. Now, the other thing to know about me as your instructor is that I will focus very much on communication as the central feature of mediation. What I've learned and what I experience every week when I do mediation is the crucial nature of communication to this process. So let's start our journey by taking a look at alternative dispute resolution with this brief overview.
12 years after a divorce, what percentage of non-custodial parents talk to their children at least once per week? Your choices are A, 14%, B, 18%, C, 32%, or D, 52%? The answer in about 1 minute. You have options for resolving your conflict: mediation, conciliation, arbitration, collaborative law, and dispute intervention through probation are all options for solving your own conflict. Each of these options includes someone with training on conflict resolution, helping you to find solutions. There are many advantages to solving your own conflict through one of these alternative dispute resolution services. Studies show that parties are more likely to stick to an agreement reached through alternative dispute resolution. You can create a solution to your problem by working with professionals and each other to share information. Once you understand each other better, you can find a solution that addresses each of your concerns and ultimately works for both of you. In most dispute resolution, you also have more control over the process by which you reach solutions. In alternative dispute resolution, you often have control over where and when the meetings are held, what type of process is used, what professionals you will work with, and how you will each share information. You can use alternative dispute resolution processes to resolve all issues in your case, or to reach partial resolution even if a full settlement isn't possible. The information that you share in some alternative dispute resolution options is kept confidential, which encourages settlement. Confidentiality does not apply in all of the options. Mediation, arbitration, and collaborative law are private and confidential processes. Dispute intervention through probation is not a confidential process, and in conciliation, some information will be reported back to the court. Creating solutions that you both buy into offers you an opportunity to rebuild relationships that may be necessary for your well-being and for the well-being of others in your family, including children. The court process can be a drain on financial and emotional resources. An average lawsuit in America can take over 3 years to reach trial or settlement. Dispute resolution moves at your pace, and if settlements are reached early on, you both can avoid the stress and cost of further court hearings. And now the answer to our earlier question. How many non-custodial parents talk to their children at least once per week, 12 years after their divorce? The national average is 18%. In cases that were litigated in court and did not use any dispute resolution service, the average is 14%. But in cases where parents went to at least 5 hours of mediation before going to court, they were significantly more likely to continue a relationship with their children. For these cases, the average was 52%.
You have options for resolving your conflict. In mediation, a neutral will assist you in resolving your conflict. In mediation, you each have a chance to share your concerns, and the mediator helps you to find solutions that are mutually acceptable to both of you. Mediation is voluntary and confidential. In conciliation, a neutral private attorney appointed by the court assists you in assessing the strengths and weaknesses of your case. You each have a chance to share your concerns and explore the options for resolving the matter without going to court. The conciliator will report to the court a list of resolved and unresolved issues, and may also share an assessment or recommendation with the court. In arbitration, you select a neutral private arbitrator who provides a binding or non-binding decision at your request. The arbitrator's decision is made after hearings and presenting of evidence which may be the same or less formal than court. In collaborative law, you are each represented by a collaboratively trained attorney, and everyone works together with a collaboratively trained coach facilitator who serves as a neutral and helps manage conflict. The professional team assists in solving conflict by finding shared solutions that take into account your highest priorities. In collaborative law, each professional focuses on how their specific expertise can help you find solutions. Like mediation, collaborative law is voluntary and confidential. In dispute intervention, a probation officer meets with the parties and their attorneys to identify the issues before the court, explore solutions, and provide recommendations if requested by the court. Information obtained during the dispute resolution process will be reported to the court. Participation in the dispute intervention process may be required in the probate and family court, but there is no obligation to settle. parties decide on the terms of agreement, or if unable to settle, their issues are presented to a judge for determination. You have the option of solving your own conflict through any of these different options and presenting your agreement to the judge.
So as you can see, this video overviews the area of ADR. Now, this particular course is on mediation. So one of the questions that I get a lot is, what is really the difference between mediation and arbitration? Really, between any of the forms that we talk about in terms of ADR, we have to first clarify the role that you might be playing if you are using one of these formats. And I like to clarify the role from both sides. So let's say you're the mediator. You would want to be very clear about what are the behaviors that are true to that role and not overstretch that role. Same with arbitration. And on the other side, when you think about a disputing party participating in any of these ADR forms, they would need to know their role as well. Now, one of the reasons we talk about mediation and why it's becoming so popular is mediation is very interesting in that the role of the mediator is to facilitate the disputants finding their own solutions. And this is something we're going to talk a great deal about in this course, the idea that it has self-determination, or that the individuals who are involved in the dispute resolution have the option to make their own outcomes. And so with the help of that third-party facilitator, they do that. Now, like I said earlier, we want to distinguish mediation and arbitration. And lawyer David Hirsch gives us some great perspective here in this next clip.
Hi, I'm Dave Hirsch, and I'm a trial lawyer. I'm one of the members and leaders of the Berg Simpson, Eldridge, Hirsch, and Jardine Commercial Litigation Department. I try civil cases, and today we are going to discuss a question that I get regularly, which is, what is ADR? You may have heard that term. ADR stands for Alternative Dispute Resolution, ADR. One of the important things to remember about ADR is that it's not the same as going to court. ADR is designed to help you resolve your cases before you go to court. It includes mediation or arbitration and then some other things. But the two large ones that we often talk about when we say ADR are mediation and arbitration. Sometimes people are confused about the difference between mediation and arbitration, so we're going to talk about what happens when you mediate. The key to remember in mediation is that it is a negotiation to try to reach a compromise. It's not a decision that's rendered by someone else. So let's take for an example. If you have a case and you decide that you're going to mediate your dispute, you would select a neutral, a third party, doesn't have a dog in that fight, who would help the parties negotiate to an agreed upon resolution. Anybody can mediate a dispute at any time. You can mediate before you go to court. You can mediate after you filed your case. You can even mediate after the case has been decided by the jury. Mediations involve a third party, a neutral, as I said, and so that usually has an expense involved, and so the parties will have to pay for the time of the neutral. One of the things I've found is that a skilled neutral is able to help parties overcome some of the objections that they have and reach a point where they can agree on resolving their case. There are three things that are really important in a mediation that are real advantages. Number one, it's confidential. Number two, you have control. And number three, it involves compromise. It was alliterated, right? That was pretty good. All right. Confidential. Mediations are confidential. It's not like a decision that you have in court because you're going to be in a private place with private parties and you can agree to keep it confidential. Number two, I said it has control. And what I mean by that is when you go to a decision maker, whether it's a jury or a judge, you lose control. Someone else is going to decide about your case. But in a mediation, the parties have control over deciding what they're going to do. Oftentimes, that's a very appealing thing. The third important aspect of mediation, it involves compromise. I've been involved in thousands and thousands of mediations in my career. It always involves some sort of compromise. The best compromise is one where both sides are a little bit unhappy. You may have heard that saying. Mediation allows an atmosphere where you can work together to try to compromise your disputes. All right, so we've been talking about mediation. What's an arbitration? Well, First of all, an arbitration is one where there is a decision maker. So it's kind of like court in that you go to the arbitration, there is an arbiter, an arbitrator, both are correct terms, but a person or people, a panel, maybe 3 of them, who make a decision. Both sides present their case to the arbiter, and the arbiter makes a decision finding in favor of one side and against the other side, or making a determination that's somewhere in the middle. Obviously, because it's not in court, there's cost involved, so you're going to have to pay for the time of the neutral who's going to make the decision. Number 2, you have to select someone you have a lot of respect for because both sides are going to be stuck with their decision. And thirdly, you have to relinquish that control of negotiating and controlling your own case, and you give it to the arbiter who makes a decision, calls the ball, calls the strike, decides how the case turns out. You can have a court trial, a public trial, or you can engage in some sort of ADR, alternative dispute resolution. One of the great things I love about ADR is that you can be creative. What are really the issues that are bothering you? So if you go to court, you're limited to the legal issues. But when you go to ADR, there may be a lot of issues that surround your case, the ongoing relationships of the parties, issues that wouldn't necessarily be legal issues but are very important to people, like maybe apologies or agreements to cooperate in the future. Those are things you can't get in court, but you can get in ADR. Now, I think that every party to a dispute should engage in some form of ADR, whether it's a mediation or even a full-blown arbitration, before they go into court to make a determination. But in any event, hopefully that answers some of the questions you may have about what is ADR.
As you can see, David Hirsch gives us some really good perspective, especially on the idea of control. Now think about it for a minute. When we're talking about the amount of control, the judge has all the control when we go to formal court proceedings, but in mediation, in contrast, well, the disputants have more control. So the question is, what is the most suitable format for the different disputes out there? And the current trend is that mediation will become a more and more popular format as individuals are able to engineer their own outcomes. So let's think about the role of the mediator more specifically. The idea behind the role of the mediator is that the mediator is really a neutral, facilitative third party. Now, when we talk about neutral, we mean that the mediator isn't on any one side. The mediator has no stake in the game. Neutral in that they are simply an outside perspective to guide the conversation. Now, when I think about mediation, that's how I think about it. I think about conflict as being a very chaotic and truncated form of communication. When people go into a conflict situation, they tend to shorten what they say. They say things like, no worries, or it's not a big deal, or you're a jerk, or some other shortened phrase that strips it of the actual meaning they wish to communicate. Now that combined with the unstructured nature of conflict leaves us with a very chaotic outcome. So what is mediation alternatively to the idea of conflict? Well, it's basically the opposite of those things. It brings structure to chaos, and it brings elaboration to truncation. What does that mean? That this is where we sit down with a third-party neutral facilitator to talk about the details of what's going on and see if we can get through to some outcomes that those disputants design for themselves. Now, we talk about mediation as a voluntary process. And when you think about it as a voluntary process, it's really changed over the last decade, I'd say. Back a decade ago, we would approach people and say, would you like to try mediation? We would say it's a voluntary process. Today, some judges will even order people to try mediation. And the reason they're doing that is they believe it is a more suitable process for those disputants. When you think about it being voluntary, the voluntary part really isn't in the trying. So a judge might order you to try mediation. Doesn't sound voluntary to me, right? But the idea is they're saying, I want you to try this process. And the voluntary part is whether you come to an agreement or not. Now, this is something we have to explain to people every week in court because they don't necessarily understand the idea of being ordered to mediation, but having it be a voluntary process. So they're ordered to try it, and it's voluntary if they wish to solve it there. Now, we talk about mediation as collaborative, and it requires a lot of effort on the communication side. We have to exchange ideas. We have to listen carefully. We're going to go into all of those behaviors and talk specifically about mediation. But the idea is that we have to work together. Now, this is something precisely that the people in the conflict haven't been doing all along. Likely, they haven't been working together. Likely, they haven't had structured conversation. So we are able to provide that as mediators. Now, we talk about the mediation process as confidential. Now, most people who are in that setting, when I tell a disputant or set of disputants that our process is confidential, mostly they hear that as, you're going to keep my secrets. And while that's true, we want to differentiate it actually more formally than that. When we talk about mediation as confidential, we talk about it as a separate process from formal court proceeding or from a formal way of managing the conflict. So this is a more informal way, but very structured in nature. When we talk about it as confidential, though, in terms of a court setting, we might say that it's confidential in that what happens in mediation stays in mediation, but that we also would be starting completely over if we went to the judge. And so the processes are very, very different in that way. The other part that's confidential is that my role as a mediator is protected. And so that means that because it's a confidential process, I can't be called as a witness or serve as a party for the current lawsuit or any future ones regarding mediation. Now, that's important for all of you who are interested in mediation to know that you will need to sign confidentiality agreements, not just because parties like to have their secrets kept, but also to protect you, so that you keep mediation where mediation starts, wherever said in mediation stays in mediation. Now, a minute ago, I talked about the neutral nature of mediation, this idea that we are neutral third-party facilitators. We're impartial, and so we don't side with other people. We don't try to create theories that help people think one thing or another. In fact, we have to be very open. And partway through this course, we're going to be talking about this idea of the bias that you and I bring to mediation, or to really all of our communication, and that we have to continually combat that in terms of our language, our gestures, all of the things we do communicatively in order to stay neutral. So in summary, what is mediation? It's bringing structure to an unstructured situation and helping parties do the work they failed to do outside of mediation. You might find it interesting to know that for the small claims cases that I do, and this has been true every year I've done them, that about 50% of the time the parties haven't spoken. 50% of the time. That's 50. It's a really surprising number. In fact, startlingly high in an era where we have cell phones, email, we could text people, leave notes, have conversations. All these different formats are available, and yet that number seems to stay the same over the years. You'd think it would go down with all the options available, but that's not really true. And so what we find is that some parties haven't even spoken at all, right? 50% of them. And so that's our option in mediation, to help those parties engage in that conversation. Now, let's talk more about the mediation process through the eyes of lawyer Jerry Slesky as he talks about mediation.
There is no issue too complicated for mediation. I don't care if there are 8 to 10 difficult issues that are intertwined in the case or multiple parties. The process works. And it works generally in spades. Once we get the parties down, once we talk to them and let them express themselves and start to find out what their interests are, the process works and we can come out with a successful result no matter how difficult the case is. When I walk into the room at the start of a mediation, it's a pretty serious moment because the parties are new to the process. The lawyers are kind of looking to the mediator to shape the day. I do what's called setting the table. It's a mediator's term where we go over all the rules for that day. And once we get started with each party telling their story, then things start to melt down. We start to get a flow in the mediation, and a lot of really good results come out of that once we get the parties to that point. The fact that they commit to show up for the mediation is huge in and of itself. And once they get there, and after the first half hour or so where they've each told their story, they start to get comfortable with it. I think I'm asking enough probative questions of them where they start to feel like we do care and we are searching for a solution to help them find a solution. And once that comfort level sets in, we've got a positive day going. It's important in mediation that the parties understand that what the mediator is doing. First of all, he's neutral, and he states his neutrality at the start of the mediation. He's there to help facilitate negotiation or conversation between the two parties themselves, who end up crafting their own deal. That's a really important part of mediation. It's not trusting the mediator, it's trusting the process. In a successful mediation, the interests of the parties are tapped into, and we use those interests to find a result that's satisfactory to both of the parties. And litigation and the results from litigation don't do that. That's a judge or a jury and a judge making a decision for you that doesn't necessarily take into account your interests. If the parties become a bit adversarial, we meet with them individually and their attorneys if they're there, and we try to get them back to helping themselves find their own solutions to the dispute. And generally speaking, when you put parties in a room, and they express themselves and they get their feelings out, it's amazingly tranquil once that takes place. It opens the doors to a huge amount of opportunity to really dig in and help them solve their problems. As the day wears on and the mediator spends more and more time with the parties and vice versa, I think a mutual respect develops. They know that you know what you're talking about. They know that you've listened carefully to what their concerns and what their issues and their interests are. And once you get past that point of achieving their confidence, then the door's open to a successful result. Another really important thing that comes out of a positive mediation is that the process is totally confidential, and the agreements are totally confidential, unlike a court case that's out in the public. And the parties can go on with their lives with their business reputation secure and strong, and nobody really needs to know what took place except that apparently it was a positive result.
And you heard him say that disputants design their own outcomes. Now, this is a very important idea in mediation, the idea of the neutral third-party facilitator. Now, sometimes, I will be honest with you, I'll be in a mediation and I'll think of a great solution. But I know that I can't do anything about that great idea. That the only great ideas are the ones that come from the people that I'm serving. And so I have to stay neutral, and that might mean not even sharing a good idea. So we're neutral third-party facilitators. Let's look at this next clip that talks about why people would use mediation.
I've been in the practice of law now 38 years. I've been with several law firms, all of which had significant litigation departments. I knew the cost in dollars and human pain and suffering of going through a very significant piece of litigation. And I always felt there was a better way to do it. When I was first introduced to mediation about 5 or 6 years ago, I just became passionate once I saw that you could cut through a dispute, break it down into its pieces, get the parties talking to one another, with or without attorneys, depending on whether it's in litigation or not, and to see them after 6, 7, 8 hours come to a resolution and sign up a binding agreement is absolutely the most professionally satisfying thing I've done in my career. The minimum cost of starting out a litigation is about $10,000 to $20,000. And most pieces of litigation will go on for several months, if not years, and will end up costing somewhere between $25,000 and $100,000 per party. Mediation generally gets done in a day, and the cost to each party generally does not exceed $2,500. To resolve disputes in this way is far, far better than anything I've ever seen. Mediation has no downside. Whether you're in litigation or thinking about litigation, to attempt to resolve a dispute through the use of mediation is a totally confidential process. Nothing said in that room can be used in a court of law. And if it's not resolved, then the parties can go on and litigate as much as they want. But at least they'll know that they tried.
So you heard him talk about the idea of confidentiality, and you also heard him talk about the idea of lower costs. As we think about this could be a good outcome for a lot of different people. Let's hear more about his conversation about success stories.
It's very exciting to me because honestly, I don't think I've ever not been able to convince somebody to try this. This is the way to resolve disputes, and if we don't make a deal, then they can always go to court. I was hired by two ladies who were partners in a business. They'd formed the business and had operated it for about 3 years, and they had built quite a successful business. One of the ladies had no money to put into the business, but put an awful lot of sweat energy, and the other one had the money to put it in. And they both worked shoulder to shoulder, side by side for 3 years and built, as I said, a pretty successful business. The lady who didn't have the money was promised 25% of the company, and that stock was never issued. And in the third year, she asked several times, had her lawyer send a letter requesting it, and it was denied. And as a consequence, a lawsuit was filed by the lady who didn't have the money to get her 25% stock interest. Each of the parties had spent over $100,000 each to prosecute this lawsuit. And when it came in front of a judge here in the district court in Douglas County, the judge had said to them, why don't we try to mediate this case before we have a full trial on the merits of this case? So during the mediation, after I heard both of their stories in the morning, I met with each of the parties and their attorneys separately, and I learned some things that helped me work with them as a neutral to achieve a positive result. What I learned in private session was an interest, a big interest of both of them. And once I knew the big interest of each of them, and I'm the only one who knew it out of the two attorneys, the two partners, and myself. I'm the only one that knew what both of their big interests were in getting resolved there. I get excited about the process because I pretty much know that I can go back in the room with everybody and use those interests as a way to help them craft a solution. The result of this mediation was a huge time saving, a lot of money saved, and as I say, most important of all, these two partners, after 3 years of grueling litigation, came away as friends, and I know that that relationship exists today. Those are good results, and they give a mediator and the attorneys and the clients a huge amount of satisfaction.
So as you can see, there's a lot that goes into mediation from all of those videos. There's so many different ideas, and I'm excited to explore them with you. But before we do all of that, I want to briefly talk about the theoretical underpinnings behind this idea of mediation and why it would work. I mean, essentially, that's the question, right? Why would something like mediation work? And so we return to the previous documents that have been written by Vygotsky. Now, Vygotsky was a researcher who wrote a very prominent work called Thinking and Speech. And his contention was the idea that when you and I have abbreviated forms of speech, when we truncate ideas, when we drop ideas out, when we just say, nothing's bothering me, or whatever, or you should know, when we use abbreviated forms, we tend to have that also correlate with our thinking patterns. Meaning that when you and I speak in abbreviated formats, we also think in abbreviated ways. So what's mediation then? Well, it's facilitated elaboration. It's the idea that humans are very prone to abbreviated speaking and thinking. And so what does that third-party facilitator do? The third party comes in to help the form of communication become more elaborated. And with that idea, then the thinking becomes more elaborated. In other words, the mediator helps facilitate the parties to fill in the gaps. And as we do that through a very structured, formal process, we can have a much better outcome for everybody involved. So think about the idea of having a structured conversation, that's what mediation is, and think about what it does theoretically, this idea that we elaborate what has been abbreviated so that parties can see and understand those elements. Now let's talk about the benefits of mediation. You've heard already that it's lower cost, that people determine their own outcomes. Let's hear from the Indiana court system on what they suggest are the benefits of mediation.
At the beginning of this video, we noted several benefits of choosing mediation over formal court proceedings in order to resolve your disputes. Some of these benefits include you and the other party can maintain more control over the resolution of your own problems, including which problems you wish to be resolved. Disputes can be settled promptly. A mediation session can be scheduled as soon as everyone agrees to use mediation to resolve your disputes, even before a lawsuit is filed. Mediation costs can be significantly less than taking a case to court. Mediation can promote better relationships through cooperation, creative problem solving, and improved communications. In mediation, you and the other party are more likely to abide by agreements that you created yourselves. Mediation is private and confidential. You, the other party, and any attorneys and the mediator may not tell the family law judge the information discussed or disclosed during mediation. Mediation is voluntary. Although a judge may order a case to proceed to mediation, settlement is entirely voluntary. Also, this process may be terminated at any time during the session by the mediator or by you or the other party after 2 sessions. If you cannot reach an agreement, you still have the right to take the dispute before a judge. The specific interests of your children are carefully considered in mediation. In Indiana, mediators are responsible for ensuring that you and the other party fully consider the best interests of your children and the consequences of any decision reached that will affect your children's lives. Mediators can also refer parties to parenting classes or counseling in order to help reduce conflict and maintain a more positive parenting relationship for the sake of the children. In some parts of the state, there are also special programs designed to help parties in family law cases maintain a strong focus on their children's well-being.
So as you can see from the Indiana court system, there are a lot of benefits to mediation. Of course, mediation promotes understanding. It also promotes that elaboration that we talked about from the theoretical side. And there's another part to really talk about, because I think this makes a lot of sense as we go across different contexts. What mediation does is it provides or helps provide differences in consequences. So let's think about that. When I worked for many years in youth mediation, we used to train peer mediators to do youth mediation with their peers, so 6th, 7th, and 8th graders. And when they would do these peer mediations, they would be able to reduce the outcomes for the disputants, meaning that they wouldn't get in trouble with the principal or the vice principal for some of their actions. The idea behind the school's commitment to youth mediation was that it was better for individual students to engineer their own outcomes, to work through their problems, if you will, than it was to just punish them for those ideas or actions that they took. Now let's think about how that works in small claims. When you think about the consequences of small claims, we call that the court of quantifiable loss, meaning small claims is really about money. And so, of course, what are the consequences? Well, if you were a defendant in the small claims case and you lost, you might lose $10,000, the maximum amount there, and you might have that affect your credit going forward. Now, alternatively, if you do mediation in small claims, the outcome is very different. One, you might still agree to pay some money, or you might not, depending on how it works out. But regardless of the outcome, when you get a written agreement, the consequence is different on the side of the credit, meaning that nothing goes on your credit report. There isn't a judgment entered against you. Instead, a mediated agreement in the form of what we call a stipulation replaces that. Let's think also how this operates in civil harassment. When I work with parties in civil harassment, we are working usually on cases that involve violence, threat of violence. We have persistent, ongoing, unwanted behavior, and sometimes that includes stalking or other behavior. And essentially, if you were to have a judgment against you in civil harassment, then you would have a restraining order permanently filed against you for a number of years. The judge would determine how many those were. And that goes on to a system that might affect your employability going forward, where employers look through the system to see if you have any background that would be suspicious or create a problem for the job service that you're doing. Now, alternatively, if you were in mediation with me in civil harassment as a mediator, then I would be able to create with the parties, and as long as they agreed to it, a new code of conduct. And what does that mean? Well, that's also a stipulation, but it's a stipulation that details the type of conduct that is and is not allowed between the parties. Now, what are the consequences to that? Well, they're very different now for the defendant, or we call respondent, in a civil harassment case, because if the respondent agrees to that new code of conduct, then nothing goes on that record. And so what does that mean? There's no restraining order, and that the outcome is, as long as they follow those new set of standards, there isn't a consequence perhaps to their employability. So think about what I've talked about in terms of the consequence, getting in trouble with the principal, or maybe having a judgment that affects your credit or your employment. Mediation, besides having all of the benefits like understanding and elaboration and all those things that are great, reduced consequences, less hurt feelings, all those things, there's also some real consequences like I talked about in the actual legal system. What is that also reflective of? I think, in my opinion, the favorable view of mediation as an alternative, hoping that people will work out their issues rather than have to have someone like a judge decide them on their behalf. Now, let's talk about DERPA. DERPA is a very important term that we're going to use in this course. And back in California's history, we used to be able to call ourselves mediators without any sort of formal training, and that's not true. In 1986, or not true anymore, in 1986, we enacted what's called the DERPA law, the Dispute Resolution Programs Act. And in 1986, a new set of standards came into place that made requirements standard for all mediators in California. Now, these are different state to state, but let's talk about the California requirements, and that's what we'll be teaching in this course. Some of the things that the DERPA standard talked about when that act was enacted was the idea that dispute resolution is very time-consuming and very costly. And so the DERPA 1986 law was put in place to go against that time-consuming, expensive process, meaning we don't want to overload the courts. We want to give people a real alternative, but we want to do it with some standards. So the law that was placed in 1986 encouraged mediation programs, and with some uniformity, established sort of a favoring of those systems. And so under the DERPA law, all of the mediations that are set to that standard require that we provide a written statement of the outcome of mediation. And we do this in court. We call it a stipulation. We also do it in community mediation, where we do these DERPA agreements, we call them. And we use a special DERPA form, meaning that we're following the DERPA guidelines. Now, the other thing to know is that sometimes people confuse whether mediated agreements are enforceable. And this is a really interesting comment to talk about, or thing to talk about as we think about mediated agreements. When we talk about a stipulation that is agreed to in small claims, for example, and let's say somebody agrees to pay me $500 on the 1st, and then another $500 the next month on the 1st, for $1,000 total settlement, we're writing a stipulation on how that happens. So we're actually, unlike the formal court proceeding, we're detailing how that payment happens. Now, that's very different than if you won the court case in trial. So let's say you won a $1,000 judgment. You would have that $1,000 judgment, and then the judge would say, good luck collecting your money. Now, that seems a little harsh, because you think about, wow, the judge will find in favor of my case, but not give me a way to try to collect the money. But in mediation, we actually go through those details. Now, we can't use that document, though, and say, see, you should arrest that person. They didn't pay me $500. Well, that's what we're talking about when we say it's a non-enforceable document, meaning we don't call the police if you don't do what's said on that paper. But we do know that on that same piece of paper in small claims, it will go to a default judgment against you if you don't follow the terms of agreement. So then sometimes people say, well, then what's the downside of mediation? And honestly, I don't see a lot of downsides to mediation. Now, certainly, I'm biased, but it's the idea that we can help people actually get a solution to what they're doing. Now, the same thing's true when we do civil harassment stipulations. So when we do a stipulation in civil harassment, we're creating a document that describes the behaviors that the parties will follow. Now, could you, if somebody broke a rule on that piece of paper, could you call the police? You could call the police, but it wouldn't be that document that would throw them in jail. It would be a determination made by the police. But what we would say about that document is it does have legal consequences, meaning you could use it as evidence that you tried to work out your problem, and also that you had a set of behaviors that the police have been notified that weren't followed related to that document. But is that document a restraining order? No, it's not a restraining order. And this is a common misconception in civil harassment cases. So what are we really trying to do in the big picture here? We're trying to get people to work out their own problems and help them understand what options are available to them. People are always surprised at what we talk about in mediation because so many people don't know what a great option it can be. Now, not every court system has it, but even in Orange County alone, last year, there were about 2,000 mediated agreements made in the Orange County Superior Court system, and that meant that 2,000 cases didn't go to trial, but had mediated agreements. Think about the relief that gives the overall court system throughout the system. It's less time consuming for the judge and for the courthouse, and also saves quite a bit of money. Now let's talk a little bit about the DERPA regulations. There are some set standards that mediators have to follow in terms of those regulations and requirements. And I want to talk about those standards, and then I want to talk about what we'll do in this course to try to meet those standards. So we know that it requires a minimum of 25 hours of training, including lecture and discussion, that's part of this show, as well as role play and observation of actual mediations. We have to talk about some required topics. So that's some of the history. We talk about some of the mechanics. We talk about how to make those mediated agreements and what are some of the forms and things that we would do related to that. Of course, we'll talk about the structure of the legal system. I talked a little bit about that today. The idea that we use mediation in mainly in small claims, unlawful detainer, and in civil harassment in our Superior Court system in California. We also know that in DERPA training, we have to have common terms that we use, that we have standards that we follow. One is being neutral. And so we'll also talk about recusing yourself from a situation due to a conflict of interest. I have done that before, where I didn't have the ability to fairly operate in a mediated situation, and you have that option as a mediator to say you have a conflict of interest and ask to be replaced as a mediator. We'll talk about some ideas of privacy and confidentiality. We'll detail the agreements. We'll also talk about what is binding and non-binding. We'll also talk about things like what does it mean to dismiss something with or without prejudice. And we'll talk about some of those ideas going forward when we get to those mechanics. Now, of course, my favorite part of the DERPA requirements are all of the training issues in communication. And so as we talk about communication, we're going to talk about every aspect of it. We'll talk about speaking. We'll talk about listening. I'm asked all the time, what is the most important communication tool in mediation? And I would say it is the question, asking a question, and hanging around for the answer. We'll talk about probing. We'll talk about paraphrasing, perspective taking, two-way commonality statements, forming common agreements. We'll talk about how we move through stage 4 of negotiation, which I'll get into, negotiating off of positions and moving on issues. And that'll be a key area where we can try to get parties to actually agree. And then, of course, we'll talk about the required paperwork. So we'll start with intake. What do we do when we intake a case? How do we assess that? How does that go from maybe an agency I'm serving versus a court system? How do we determine what's suitable for mediation and what isn't? And then we'll also talk about how we follow up and report and what are those obligations in terms of our mediation paperwork. So the other question that I brought up a second ago is, what do we do in an online learning format to meet the standards of the interactive standard of the DERPA requirement, meaning we have observations and we have role plays that we have to do in order to meet the DERPA standard. Now, previously when I've taught this course, we haven't been able to meet that standard simply because we didn't have the technology or the time or resources to be able to actually devote to doing that work through other formats. In other words, it was too difficult to bring everyone together in an online format to meet those standards. But the great news is that starting this semester, we're able to offer the other 10 hours through the Zoom format. And what does that mean? Well, Zoom, like FaceTiming or Skype or any of these other collaboration formats, we're going to use that to actually meet the rest of the DERPA standard. And so we'll do role plays over Zoom as part of the course, and that will give us the option to really look at some of the mechanics and practice the actual mediation part. Now, some of you may say you're not interested in meeting the DERPA standard. And so there's going to be really two avenues to complete this course. One is through doing it just on the theory side, and that's just in its current state without Zoom. Or for those of you that are interested in meeting the DERPA requirements, you'll be engaged in the Zoom activities as well. And so those are two kind of different ways to complete the same course and get your training in mediation. Now, I know I've talked about a lot of different basic ideas today. We've talked about alternative dispute resolution. We've talked about mediation and how it's different from arbitration. We've talked about even some of our roles as mediators and some of the aspects that are required in mediation. It's a lot to think about, but I'm excited to take the journey with you. So that concludes our show today and our opening to this course. And this is Dr. Pamela Kreiser wishing you peace.